You are listening to the Schoberg and Tibelius podcast, where our attorneys discuss key issues that affect the decisions you make in regard to your business, your family, and your estate. Each episode will provide important information from highly skilled legal professionals who are dedicated to helping you achieve your business and personal goals. Please know this podcast does not create an attorney-client relationship between Schoberg and Tibelius and its attorneys with the viewer-listener. The information provided herein is general and is not to be interpreted as legal advice in regard to any unique case or issue.
Hello, and thanks for joining us. We're here with attorney Roy Schoberg, partner at Schoberg and Tibelius, who has quite a bit of experience in community property and the impact it may have on your assets in the states of Minnesota and Wisconsin. Thanks for joining us today, Roy.
My pleasure. Thanks for having me.
We have a few common questions that you have the answers to that we'd like to chat through today. So I think we'll just dive in and get started.
Let's go.
When someone has a question about community property, why do you think it's important for couples to understand what community property is and the legalities surrounding it before diving into some of their deeper questions?
That's a good question. So if couples are knowledgeable about community property, then they can position themselves to take advantage of various tax benefits. And they can take steps to avoid losing those benefits if they decide to move to a state where there is no community property. But not only is knowledge about community property law important to couples, that knowledge is of significant importance to professionals who advise them, because if they don't have that competency, then the professional advisor could be subject to a claim. So often I get questions not from the couples, but from their advisors.
Interesting. What is community property specifically in the state of Wisconsin?
Well, first of all, generally, community property is defined as a type of ownership between a husband and a wife in which each spouse owns an undivided one-half interest in each item of property acquired during marriage, except for property that is acquired by a gift or a devise or descent or personal injury. Title is not determinative. Placing the property in the name of one spouse does not overcome the presumption that property acquired during the marriage is community property. And property acquired out of earnings during the marriage is presumed to be community property as well. For Wisconsin, community property is referred to as marital property, and it's codified in Wisconsin Statutes Chapter 766. And that was put into effect back in January 1st of 1986. Wisconsin became the 9th state to make community property the core law for property ownership and control in marriage. All 9 states' community property laws differ in some respects, but in all cases, title no longer controls ownership.
And with most of your clients being in Minnesota or Wisconsin, what are some of the differences in community property between Minnesota and Wisconsin?
Well, Wisconsin is a community property governed state, but years ago, Minnesota decided not to convert from common law property to community property. Thus, in Minnesota, title does denote ownership. But even in most common law states, such as Minnesota, spouses that do not have title to property still have some ownership rights, which come into play with vigor at time of divorce. In addition, surviving spouses in common law states like Minnesota usually have rights that protect them upon the death of a spouse who held title, and these rights include rights to spousal maintenance, homestead rights, and, depending on the length of the marriage and the absence of a prenuptial agreement, elective share rights. Now, back in Wisconsin, a surviving spouse already owns one half of marital property, even if the marital property is held just in the name of the other spouse. So accordingly, surviving spouses in Wisconsin are not granted elective share rights because, again, the surviving spouse already owns one half of the property.
So, knowing that, what are a few problem areas with community property that are important for anyone listening to this podcast to note?
Well, in some of the presentations that I've made to members of the Minnesota Bar, I have referenced a number of watch out for this scenarios, and I'll describe a couple of them right now. First, when a business owner moves to a community property state such as Wisconsin, even if the shares of stock are titled in the name of that business owner, if income is reinvested into that business under circumstances where Wisconsin marital property law applies, then the business owner's spouse will own one half of the business owner's shares. And if then the business owner's spouse dies and leaves his or her estate to his or her children of a prior marriage, the business owner will need to buy those shares back in order to keep those shares from passing to those children. So that's a real problem for business owners who move from Minnesota to Wisconsin. But another problem that arises when a couple moves to a community property state and fails to change the title of a highly appreciated asset from the former ownership to a new account that can be classified as community property. In such a case, the missed opportunity of qualifying for the tax advantage double step up in basis could be lost. Not only would the couple be disappointed, but if a professional planner missed this, that professional advisor could be sued.
Wow. So what are a few considerations for preserving the community property nature of assets brought into a common law state?
Well, a lot of considerations are out there. In fact, I helped to write some legislation known as the Uniform Disposition of Community Property Rights at Death Act, because without that, there's really not very much guidance to give the courts on how to treat community property that moves into a state like Minnesota. So that's a way of maybe lessening some of the court cases that have to go through because this is just an open area. But there are ways of preserving community property, such as leaving it in a trust that would be labeling that property as continuing community property. But let me give you an example of why it might be very important for a couple to preserve their community property. So let's assume that a couple moves to Minnesota from Wisconsin. But while living in Wisconsin, one of them invested $50,000 of their earnings in a startup company, and as a consequence, that $50,000 has grown to, say, $1 million when the company went public. So this is community property. And if the couple preserves that community property ownership, then upon the death of either spouse, even though they've now moved to Minnesota, those shares would get a step up in income tax basis to the full current value of $1 million. And that would allow the surviving spouse to sell those shares without having to pay any capital gains tax at all. And this would also allow the surviving spouse to reinvest 100% of the proceeds into a more diversified portfolio. But on the other hand, if the couple moving to Minnesota placed those shares into a jointly owned account with the right of survivorship, that would destroy the community property nature of the shares. And then only one half of the shares would receive a step up in income tax basis at the death of a spouse. So capital gains would be taxable on the other half. So it's a great benefit if we preserve community property.
It sounds like it.
Yeah.
What would be the best way for someone to understand their own situation in regards to community property and keep their assets protected?
Well, a couple who is residing in a community property state like Wisconsin, or is about to move from a community property state to a common law state, say moving from Wisconsin to Minnesota, or the reverse is about to move to Wisconsin from Minnesota, they'd be well advised to meet with a professional advisor who is competent in community property law. And we at Schoberg and Tibelius are able to provide competent estate and planning advice that involves community property law issues. Whether a fellow lawyer or a new client, we hope you will contact us to discuss your circumstances.
Perfect. And what is the best way for someone to get in touch with you to learn more?
Well, please visit our website, which is stlawfirm.com, or you can call us at 651-738-3433, and we'll be happy to speak with you about your concerns.
Perfect. Thanks so much, Roy.
You're welcome. Nice to talk to you.
You too.
When you are searching for legal insight to guide life's important decisions, the highly trained attorneys at Schoberg and Tibelius are here to help. Call us at 651-738-3433 and follow us on our Facebook page at Schoberg Tibelius to get notified about our most recent podcast episodes. See you next time.